Hello and welcome. Are you unable to work? Are you in the process of filing your application for Social Security disability benefits? Or have you already been denied and waiting for your hearing before the administrative law judge? Whichever it is, you should review this video and our video covering our tips report, which gives you valuable tips covering all stages of the Social Security disability claim process. Specifically, in the tips video and report, we give you tips on how to financially survive what could be a lengthy appeals process, how to avoid common pitfalls when completing the disability application, how to present your case in the application, how to increase the value of your case, how to check to see if your case qualifies for expedited claim processing, how to shave off several months for a hearing-level decision, how to avoid common pitfalls during the hearing, how to testify, and how to retain benefits after you win your case. In the introduction video that you are listening to right now, you will learn how the Social Security Administration defines disability, the qualifications for SSDI or SSI benefits, the Five-Step Sequential Evaluation Process used to determine whether you meet their definition of disabled, the Residual Functional Capacity, and why it is critical to your success, the Special Medical-Vocational Profiles, how the grids work, how to establish a less-than-sedentary residual functional capacity, and the key to winning your case. We are confident that this intro video and our tips video and report will significantly strengthen your claim and dramatically improve your chances of winning your Social Security disability case. Who we are is USA Disability. Social Security Disability advocates asserting the rights of claimants nationwide. Attorney Michael O'Connor started his Social Security practice by conducting many hundreds of Social Security disability trials for local and national law firms. Over the years, he learned many valuable tips that he wants to share with you in this video and his tips video and tips report. Before we begin, please click the like button to improve this video's rankings so that others can locate it more easily. Please share this video with anyone you know suffering from a disabling condition. Click the free case evaluation link below if you want us to represent you. Now let's get started.
Know that disability is not easy to obtain. It can be tough to qualify for disability, especially for younger people under 50. Out of all the countries in the world, the United States has one of the strictest, if not the strictest, definitions of disability. Disability is not determined by your inability to perform your prior job. And disability is not determined by your diagnosis. Instead, it is determined by the work limitations caused by your conditions. The Social Security Administration administers two programs based on disability. The definition of disability depends on which program you are applying for and your age. The better of the two programs is called the Social Security Disability Insurance Program, abbreviated SSDI. The rules of that program are outlined in Title II of the Social Security Act. The second program is the Supplemental Security Income Program, abbreviated SSI, governed by Title XVI of the Act, and is a welfare program. For all individuals applying for Title II benefits, that is, SSDI, and for adults applying for Title XVI benefits, that is SSI, disability is defined as the inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairments which can be expected to result in death or which has lasted or can be expected to last for a continuous period of not less than 12 months. For a child under age 18 applying for benefits under Title XVI, that is, SSI, will be considered disabled if they have a medically determinable physical or mental impairment or combination of impairments that causes marked and severe functional limitations, and that can be expected to cause death or that has lasted or can be expected to last for a continuous period of not less than 12 months. Notice that the disabling requirement must be for 12 months. In other words, there must be medical evidence that your condition has existed at a disabling level for at least 12 months or is likely to continue for that long at a disabling level. Now you know the Social Security Administration's definitions of disabled. Before you embark on what could be a long journey, take a moment to determine whether you qualify for disability. If you are not sure, err on the side of caution and apply for Social Security disability benefits since there is no harm in applying. However, some people clearly do not qualify if they earn too much money or other easy-to-determine criteria. This discussion aims to save you some time if you clearly do not qualify. As a brief overview, to qualify for SSDI benefits, your average gross earnings must be less than the substantial gainful activity threshold, also known as SGA, which in 2022 is $1,350 per month and $2,260 per month if you are blind. If your average gross income is more than that, you generally do not qualify for SSDI benefits. Also, in general, SSDI claimants must have earned 5 years of work credits over the past 10 years in jobs covered by Social Security. You earn Social Security credits when you work and pay Social Security taxes, also known as FICA taxes. You can earn up to a maximum of 4 credits per year. In 2022, the amount of earnings it takes to earn 1 credit is $1,510 or $6,040 to get the maximum of 4 credits for the year. You must earn at least 40 Social Security credits to qualify for SSDI benefits. This translates to 10 years of work. The number of credits does not affect the number of benefits you receive. The average of your earnings over your working years, not the total number of credits you earn, determines how much your monthly payment will be when you receive benefits. To be eligible for disability benefits, your work credits must meet a recent work test and a duration work test. The number of credits necessary to meet the recent work test depends on your age. Before age 24, you may qualify if you have 6 credits earned in the 3-year period ending when your disability starts. In general, for ages 24 to 31, you may qualify if you have credit for working half the time between age 21 and the time your disability began. As a general example, if you develop a disability at age 27, you need 3 years of work, 12 credits, out of the past 6 years, between ages 21 and 27. In general, for age 31 or older, you must have at least 20 credits in the 10 years immediately before your disability begins. The duration of work test depends on your age when your disability began. For the duration of work test, your work does not have to fall within a certain period. If you are statutorily blind, you must only meet the duration of work test. There is no recent work test requirement when statutory blindness is involved. So, in sum, generally you need 40 work credits, 10 years of work, with 20 work credits earned in the last 10 years ending with the year you become disabled. However, younger workers under the age of 24 can qualify with having only 6 credits earned in the 3-year period ending when their disability starts. You can look into your work credits by reviewing your Social Security Administration statement at ssa.gov. Those who have not earned enough work credits for SSDI benefits may still be eligible for SSI benefits since SSI is a welfare program based on financial need and not work credits. This is why most claimants apply for both benefits at the same time. So, if you know you earn too much money or do not have the requisite work credits, you do not qualify for SSDI benefits. If you are unsure that your medical impairment is severe enough, go ahead and apply because you do not have anything to lose.
Over the next several minutes, we will discuss the eligibility requirements for supplemental security income benefits, so be clear that these are not the requirements for Social Security disability benefits. The amount of countable income an SSI recipient gets each month is subtracted from the maximum SSI benefit amount, which in 2022 that amount is $841 for individuals and $1,261 for couples. A list of what income does not count for SSI can be found in the links section below this video. SSI recipients must be citizens or nationals of the United States or non-citizen who meets the alien eligibility criteria. If you entered the U.S. on or after August 22, 1996, you might not be eligible for SSI for the first 5 years. You must live in one of the 50 states, the District of Columbia, or the Northern Mariana Islands, with the intent to continue living within these geographic limits, or a child living with a parent in the military service assigned to permanent duty ashore anywhere outside of the U.S., or be a student temporarily abroad to conduct studies as part of an educational program. You are ineligible to receive SSI benefits for any month you have an unsatisfied felony or arrest warrant for escaping from custody or avoiding prosecution or confinement, nor do you qualify for any retroactive SSI payments until you prove that you satisfied the felony or arrest warrant. If you are receiving SSI benefits and go to prison, jail, detention center, halfway house, boot camp, etc., even if not necessarily under confinement, you are not eligible for SSI benefits for any full month at any of these facilities. This does not apply to emergency shelters for the homeless or publicly operated community residences. In most instances, you can apply for SSI benefits and Supplemental Nutrition Assistance Program, also known as SNAP, benefits several months before being released from one of the previously mentioned institutions. Also, except for certain students temporarily abroad for study purposes, or a child of military parents stationed overseas, an individual is not eligible for SSI benefits for any month during all of which they are absent from the U.S. for a full calendar month or 30 consecutive days or more. That is a brief overview of the eligibility requirements for SSI benefits. Now you should know whether you clearly do not qualify. However, if you are unsure, it is recommended that you apply for it. The Social Security Administration has a 5-step sequential evaluation to determine whether you meet their strict definition of disabled. The sequential evaluation steps must be followed in numerical order, except where policy expressly permits a deviation. The endpoint of the sequential evaluation is whenever the claimant is or is not disabled at a given step, then the sequential evaluation ends. At the first step of the 5-step sequential evaluation, the Social Security Administration will ask SSDI claimants whether they are engaged in a substantial gainful activity, or for SSI claimants, whether their money or assets exceed the SSI thresholds mentioned previously. If the answer is yes, the claimant is not disabled. If the answer is no, the sequential evaluation continues. Note that SGA consideration does not apply to age 18 redeterminations. The second step in the 5-step sequential evaluation applies to both SSDI and SSI claimants and asks the question: are the claimant's medical impairments severe enough to significantly limit his or her ability to do basic work-related activities, such as lifting, standing, walking, sitting, for at least 12 months? If the answer is no, the claimant is not disabled, and if the answer is yes, the sequential evaluation continues. Step 3 of the sequential evaluation asks whether the claimant's impairments meet or medically equal a listing. If yes, the claimant is disabled. If no, the sequential evaluation continues. The Social Security Administration maintains a listing of medical criteria that are so severe that an individual is found to be disabled if his or her medically determinable physical or mental impairments matches them. An individual's impairments can be found to meet the listed criteria exactly, or to be of equal severity. So, if an individual has an impairment that meets or equals one of the listings, and meets the duration requirement, he or she shall be found to be disabled. If an individual does not have an impairment that meets or equals one of the listings, or the duration requirement is not met, the case proceeds to step 4. To verify whether your conditions are among those listed in the listing of impairments, please see the appropriate link below. If your condition is not on that list, then the severity of your disease or condition will be evaluated. There are 2 expedited claims processes that exist. The first is called compassionate allowances, which qualifies claimants when the diagnosis is confirmed for severe conditions like acute leukemia, Lou Gehrig's disease, ALS, or pancreatic cancer. The second expedited claims process is called quick disability determinations, which is a computerized screening process that identifies cases with a high probability of allowance and expedites the evaluation process. Assuming your conditions are not listed, and before step 4, the individual's residual functional capacity, commonly referred to as RFC, is assessed. The RFC is an individual's capacity for full-time work, ordinarily assessed on a function-by-function basis. It represents an individual's maximum ability to do sustained work-related physical and mental activities 8 hours a day for 5 days a week despite the medically terminable impairments and the resulting limitations and restrictions. The RFC assessment is used at both Step 4 and Step 5. Step 4 applies to both SSDI and SSI claimants. This step of the sequential evaluation asks whether the claimant's impairments prevent the performance of past relevant work. To make that determination takes a function-by-function comparison of the residual functional capacity with the physical and mental demands of the claimant's past relevant work, which is generally most if not all the jobs you held over the past 15 years, then answer the following 2 questions. Does the claimant retain the capacity to perform any past relevant work as he or she actually performed it? Does the claimant retain the capacity to perform any past relevant work as generally performed in the national economy? If the answer to either question is yes, the claimant is not disabled. If the answer to both questions is no, the sequential evaluation continues. Note that at Step 4, the Social Security Administration does not consider a claimant's age, education, body habitus, employability, or whether past relevant works exists in significant numbers in the national economy. Note that no matter how restrictive your limitations are from medically determinable impairments, you will not be found disabled at Step 4 if your RFC or MRFC, mental residual functional capacity, does not preclude the performance of any past relevant work as you described it. Also, here is where the Special Medical-Vocational Profiles are evaluated after Step 4 and before evaluating Step 5. If one of the Special Medical-Vocational Profiles applies, the claimant is disabled, and the sequential evaluation ends. The three Special Medical-Vocational Profiles are the Arduous Unskilled Work Profile, No Work Experience Profile, and Lifetime Commitment Profile, which are discussed later in this video. If none of these profiles are met, the Social Security Administration will consider the Medical Vocational Guidelines, nicknamed the grids. The grids are also discussed in detail later in this video. Up to this point in the five-step sequential evaluation, the claimant has the burden of proof. So you are responsible for submitting evidence showing you have an impairment that prevents past work performance. Step 5 applies to both SSDI and SSI claimants. In Step 5, the sequential evaluation asks whether the claimant can make the vocational adjustment needed to perform other work 8 hours a day, 5 days a week, considering the claimant's residual functional capacity, age, education, and work experience? If yes, the claimant is not disabled. If no, the claimant is disabled. Note, a person is found capable of performing other work when the range and kind of work for which he or she is functionally and vocationally suited are sufficiently broad to constitute a reasonable outlook for making a vocational adjustment, and such jobs exist in significant numbers in the region in which the individual resides or in several regions of the country. Factors such as a change in residence from one geographical area to another, lack of job openings, and employers' hiring practices are not pertinent to the decision, so do not complain about any of these during the hearing. Note that at Step 5, the burden of proof shifts to the Social Security Administration to show that work, other than what the previous relevant work, exists in significant numbers in the national economy, that he or she can adjust to considering the limiting effects of the claimant's impairment, age, education, and work experience. That is the Social Security Administration's five-step sequential method to determine whether you meet their strict definition of disabled.
Let us look at the residual functional capacity and terminology you should be familiar with. The most compelling evidence of your disability is based on your residual functional capacity, which considers your impairments and any related symptoms, such as pain, that may cause physical and mental limitations that affect what you can do in a work setting. Despite your limitations, your residual functional capacity represents the most you can still do. The Social Security Administration will assess your residual functional capacity based on all the relevant evidence in your case, which is mainly medical evidence. So, scour through your medical file for functional limitations and keep a list of such citations to use on your application and at the hearing, if any, especially if you represent yourself. If your medical record lacks substantial evidence, then ask your doctor to complete the appropriate physical or mental residual functional capacity form, also known as a medical source statement, so that Social Security Administration has accurate information about your work limitations. For your convenience, see the appropriate links below for the medical source statement forms. If your medical file lacks functional limitations, then Social Security Administration's medical consultant might assume you do not have any functional limitations, and your case will be denied. On the other hand, the medical consultant could rate your limitations if there is enough information in your medical file, or order a consultative examination with the appropriate specialist, or obtain a mental status examination, which is a psychological evaluation for those with a learning disability, cognitive disorder, stroke, head injury, organic brain disorder, or intellectual disability. Exertional limitations are rated using the following 5 categories: never, rarely, occasionally, frequently, and constantly. For an exertional limitation, they consider your ability to exert yourself, such as lifting, sitting, standing, reaching forward, reaching overhead, crouching, stooping, bending, grasping an object, doing fine manipulation, hearing, seeing, etc. For example, you may have the exertional limitation to lift 20 pounds occasionally. This means that, at most, you have the capacity to lift 20 pounds up to 1/3 of a workday, that is approximately up to 2.7 hours over an average workday. The definitions of these 5 categories are as follows. Never means not even once during an 8-hour workday. Rarely means occurring 1 to 5% of an 8-hour workday. Occasionally means up to 1/3 of an 8-hour workday. Frequently means occurring from 1/3 to 2/3 of an 8-hour workday. Constantly means occurring more than 2/3 or more of an 8-hour workday. For mental limitations, they consider psychological impairments such as depression, anxiety, schizophrenia, bipolar, and obsessive disorders, etc. The Social Security Administration will consider your ability to understand and remember instructions, sustained concentration, persistence, ability to adapt, ability to interact with others, and how long you have episodes of decompensation. Mental limitations are rated using the following 5 categories: none, mild, moderate, marked, and extreme, defined as follows. None means you can function in this area independently, appropriately, effectively, and on a sustained basis. Mild means your ability to function is slightly limited. Moderate means your ability to function is fair. Marked means your ability to function is seriously limited, and extreme means you cannot function in this area independently, appropriately, effectively, and on a sustained basis. The Social Security Administration's medical consultant will determine what level of exertion you can do and what restrictions you have. The consultant will review your medical records and doctor's notes and rely upon those to determine your abilities and restrictions. Then, the consultant will use the abilities and restrictions to create your residual functional capacity assessment. Once your exertional functional limitations are evaluated, the medical consultant will ascertain your exertional level. The 5 exertional levels are as follows. Sedentary work means you can lift no more than 10 pounds at a time and occasionally lift or carry small things. A sedentary job is mostly sitting, but you must be able to walk and stand occasionally. Light work means you can occasionally lift up to 20 pounds and frequently lift or carry up to 10 pounds. Light work requires frequent walking and standing and the ability to push and pull with your arms or legs. If you can do light work, you can do sedentary work. Medium work means you can lift up to 50 pounds and frequently lift or carry up to 25 pounds. If you can do medium work, you can also do light and sedentary work. Heavy work means you can lift up to 100 pounds at a time and frequently lift or carry up to 50 pounds. If you can do heavy work, you can do medium, light, or sedentary work. Very heavy work means you can lift objects that weigh more than 100 pounds and frequently lift or carry 50 pounds or more. If you can do very heavy work, you can do all other levels as well. Suppose your doctor has restricted you to walking and standing no more than 2 hours per day. In that case, your residual functional capacity will be for sedentary work. Note that your residual functional capacity will also include any non-exertional restrictions, such as not being able to stoop, use your fingers, or remember instructions. So now you know the definition of residual functional capacity and reviewed the terminology associated with it. Let's address further how your residual functional capacity is used. Your residual functional capacity assessment will first determine if you can perform your prior job. The examiner will look at your work history for the past 15 years to see what type of work you have done and know how to do. The examiner will then compare your residual functional capacity level to the level of your past work. If your prior job was sedentary and your residual functional capacity is for sedentary work or higher, the claims examiner will probably find you should be able to return to your job unless your residual functional capacity has non-exertional restrictions like an inability to remember instructions. If you have mental or emotional limitations, such as memory problems from a psychiatric or neurological disorder, where you are unable to concentrate, DDS should create a mental residual functional capacity for you. On the other hand, if your prior job was for medium work, for instance, an auto mechanic or a mail carrier, but the medical consultant assigned you a light residual functional capacity, they will find that you cannot return to your former line of work. If the examiner determines you cannot do your prior job, they will then use the Social Security Administration's medical vocational grid rules to determine whether, given your residual functional capacity, your age, your education, and your skills, you should be able to learn another job. Scour your medical records for RFC limitations because they are the most compelling evidence of your disability. If your medical records lack enough RFC limitations, ask your doctor to complete the appropriate RFC medical source statement. Advocates are sometimes more successful at getting your doctor to complete a medical source statement.
So here is an image of the grids. The grids is a nickname for the medical vocational guidelines. They apply to claimants 50 years of age or older with physical impairments, not mental-only claims. Essentially, it is a grid or chart with rows and columns that factors in for sedentary, light, and medium exertional levels, age, education, and transferability of skills. Certain combinations of these factors make some claimants eligible for an award. For example, claimants over 50 will generally be found disabled if limited to work at the sedentary level. Claimants over 55 will generally be found disabled if they are limited to work at the light work level. The grid rules dictate that a 50-year-old claimant with an 11th grade or less education, unskilled work history, and sedentary residual functional capacity will be found disabled. A 55-year-old with a high school diploma, unskilled work history, no transferable skills, and a sedentary residual functional capacity is also disabled. However, most claimants do not fit in these categories, and the Social Security Administration may determine, at Step 5 of the Five-Step Sequential Evaluation, that the claimant is not disabled because they can do an unskilled, sit-down job. For these claimants, having a mindset of showing a less than sedentary residual functional capacity is vital. It is a good strategy or mindset to focus on establishing a less than sedentary residual functional capacity if you can. This is especially true for claimants younger than 50 years of age, since they have the hardest standard to meet. So gather your medical evidence of any of the limitations, and for as many as you can, to establish a less than sedentary residual functional capacity. Consider whether you have any of the following physical limitations that prevent unskilled sedentary work, such as the inability to crouch, stoop, or bend. The need to recline or lay down during the day, even for a short time. The need to take a nap due to fatigue. The need to elevate legs while seated. The inability to sit for 6 to 8 hours. There are also mental limitations that prevent unskilled sedentary work, such as the inability to maintain attention and concentration for extended periods. The inability to follow short, simple instructions. The inability to interact appropriately at times with supervisors and coworkers. The inability to maintain basic standards of cleanliness and hygiene. The inability to handle work stresses. Will miss 2 or more days of work per month for medical reasons, or will be off task for more than 15% of a workday, excluding regular breaks. After evaluating whether you have any of these physical or mental limitations that prevent unskilled sedentary work, make sure you gather the medical reports that support it and make a special effort to point it out on your application and during the hearing, if any.
Now for a review of the Special Medical-Vocational Profiles that we briefly discussed earlier. The Special Medical-Vocational Profiles are a list of combinations of vocational factors such as age, education, and work experience that are so unfavorable that a person who meets one of them will be deemed unable to adjust to other work and will be found disabled at Step 5 of the sequential evaluation process. Whether a Special Medical-Vocational Profile applies is determined only after finding that a claimant cannot do any past relevant work. Because the profiles only require that a claimant have a severe impairment and because an incorrect decision might otherwise result, it is important to consider whether a profile applies before referring to the medical vocational guidelines. The 3 Special Medical-Vocational Profiles are arduous unskilled work, no work experience, and lifetime commitment. For the profile arduous unskilled work, a finding of disabled will be made for persons who Are not working at the SGA level, which is $1,350 in 2022 for non-blind claimants and $2,260 for blind claimants. Have a history of 35 years or more of arduous unskilled work. Can no longer perform this past arduous work because of severe impairments and have no more than a marginal education, defined as formal schooling, completed at the 6th grade level or less. Note, this profile would not necessarily be defeated by very short periods of semi-skilled or skilled work if no transferable skills exist, or by longer periods of semi-skilled or skilled work if it is clear that the skill acquired is not readily transferable to lighter work and makes no meaningful contribution to an individual's ability to do any work within his or her present functional capacity. For the profile, no work experience, a finding of disabled will be made for persons who have severe impairments, have no past relevant work, are age 55 or older, and have no more than a limited education, defined as formal schooling, completed at the 7th through the 11th grade level. Note, it is unnecessary to complete a residual functional capacity form to determine that an individual meets this profile, since they will have no prior relevant work to compare to the residual functional capacity findings on a function-by-function basis. For the profile lifetime commitment, a finding of disabled will be made for persons who are not working at the SGA level, have a lifetime commitment, 30 years or more, to a field of work that is unskilled, or is skilled or semi-skilled but with no transferable skills, can no longer perform this past work because of severe impairments, are closely approaching retirement age 60 or older, and have no more than a limited education, again defined as formal schooling, completed at the 7th through the 11th grade level. Note, to satisfy the requirement for this profile, the 30 years of lifetime commitment work does not have to be at one job or for one employer, but rather work in one field of a very similar nature. If the person has a history of working 30 years or more in one field of work, the use of this profile will not be precluded by the fact that the person also has work experience in other fields, so long as that work experience in other fields is not past relevant work, which the person is still able to perform. The key to winning your disability claim is to show that you have substantial medical evidence that supports severe and specific work limitations. A simple diagnosis or a diagnosis without the proper objective medical test to support it is not substantial medical evidence. For example, suppose the doctor diagnosed you with rheumatoid arthritis without the proper blood test to support the diagnosis. In that case, that is not substantial medical evidence. The medical evidence also needs to go one step further and explain how your condition interferes with your ability to work. For example, suppose your rheumatoid arthritis prevents you from raising your arms above your head or precludes you from doing fine manipulation with your hands or fingers. In that case, your doctor needs to include those limitations in your medical records. To prove this, focus on the medical evidence supporting the lack of work capacity. When you follow this tip, the administrative law judge has little choice but to grant you disability or risk reversal on appeal.
You have finished the introduction video to Social Security disability. You are now ready to listen to the tips video that elaborates on the tips report, both of which can be accessed using the appropriate links below. In the tips video and in the tips report, we give you tips on how to financially survive what could be a long appeals process, tips on how to avoid common pitfalls when completing the disability application, and how to present your case on the application, tips on which claims can take advantage of expedited processing, tips on shaving off several months for a hearing-level decision, tips on increasing the value of your case so that you receive more money, tips to avoid common pitfalls during the hearing and how to testify, and tips on how to retain your benefits after you win your claim. We are confident that the tips report combined with our 2 videos will strengthen your claim and dramatically increase your chances of winning your case. If you want USA Disability to represent you, click the appropriate link below for a free case evaluation. Also, if you found this video helpful, please click the like button to improve the video ranking so that others can more easily locate it, and share this video with anyone you know suffering from a disabling condition. Thank you and best wishes with your disability claim.